So what if you could sell your business and not pay capital gains tax? Well, that's a question I am often asked by clients who are looking to sell their business. And that's obviously a question as a result of research and conversations they may have had either with ChatGPT, with their accountant, or peers in the same industry or business that they are in. So I'm hoping to talk about what that really means. Why does the question get asked? And hopefully debunk some myths and around that topic. The reason this question is asked is because it is coming from the understanding of QSBS, which is qualified small business stock. And qualified small business stock is a provision within the tax code. It's section 1202. So you will often hear people talk about 1202 or QSBS, and they're all one and the same thing. And it is a tax incentive that has been in the legislation for many years now, since the mid 90s, but it's sort of a badly kept secret, but one that people have started to pick up on, certainly in the last decade or so, with much more frequency. And it is a provision that, in essence, permits a holder or owner of qualified small business stock, and we'll discuss what that really means, to exclude on a subsequent sale of that stock, as long as they meet the appropriate criteria, exclude under the old tax law the greater of 10 times the basis value of that stock when they received it, or $10 million from federal capital gains tax. Under the new laws, which were implemented in July 4th of 2025, it's the greater of 10 times the base value of the stock or $15 million. So there was a significant change there. So this is an incentive that is available for owners of people who own QSBS. So what does QSBS mean, or what makes it eligible? I think the best way to look at that is really, what are some of the myths? Oftentimes, and where you've heard QSBS mentioned more often than not, is in the tech world, because in order to be qualified stock, it has to not be part of the business, cannot be involved in one of the excluded activities that are listed under the code. And typically, those are things that are in the professional services or services type businesses, where the business is reliant on the individual skill of the person, the owner involved. So lawyers, for example, accountants, physicians in their medical corporations typically don't qualify as holders of QSBS stock. But if we think of manufacturing businesses, if we think of tech businesses, distribution businesses, sellers, resellers of product, and so on, typically in the goods space, those are all business activities that would qualify. So we need to have a business that qualified in terms of the activity. Then the stock that you own must be what we call originally issued C corporation stock. And that's perhaps another video for what is originally issued, and in particular, some of the nuances that happen in the evolution of a business. But in essence, the day the entity was formed, the stock that was issued each time from the corporation to the specific shareholder, that would be an original issuance. And it must be C corporation stock. So if the entity was an S corporation, it is not going to qualify. But it is available for whoever receives that originally issued C corporation stock in a company that is engaged in a permitted activity, i.e., not an excluded business activity, as I mentioned earlier. So that means it could be available to the original founders, investors, to employees. So there's a whole range of beneficiaries that can have it. Corporate stockholders are not going to benefit, however. It then begs the question, well, if it has to be a C corporation, do I immediately go and become a C corporation? Does a C corporation always make sense? A C corporation is not always going to make sense. And I think that's one of the fundamental things when we're talking to owners of businesses or people are looking to start their business, is we really need to understand the business activity, their needs, their desires, their expectations, because maybe an S corporation is what is needed, maybe a partnership is what is needed. So a C corporation doesn't always make sense, but certainly for QSBS purposes, it will need to be a C corporation, and that's what we're looking at. Once that stock is issued, the question becomes, okay, I hold it. Is there anything I need to do with my business thereafter? Or do I sort of one and done and I forget about it? Well, no, because there are tests that are applied to that business in terms of when there is a sale happening and when there is an eventual exit, has that business continue to be an eligible C corporation and its business activity. And here we're talking about provisions within 1202 or criteria within 1202 that are also important to manage. So we can't have a passive business. We need to have an active business. In fact, the definition is that 80% of the assets of the business need to be you engage in actual business activity. So we need to have constant engagement of business activity. Furthermore, when the stock is issued, under the old law, so we'll always talk about under the old law and then the new provisions under the One Big Beautiful Bill Act, which was implemented in July 4th of 2025. Under the old law, the gross asset value of that company when issuing the stock had to be below $50 million. That threshold was increased under the new bill. And so for all entities that issue stock post July 4th, 2025, then the threshold is $75 million in gross assets. So this meant the net was much wider for eligible businesses in that respect. So we've talked about the assets and engaged activity and not being excluded. Then it's a question of how long do I have to hold that stock? Well, again, under the old laws, the stock had to be held for more than 5 years before it could be sold in order to get the federal capital gains tax benefit. Under the new provisions for all entities formed after July 4th, there is a tiered process. And so now it is if you hold the stock and sell it for 3 years, after 3 years, but before 4 years, then you qualify for 50% exclusion. If it's more than 4 years, but less than 5 years, then you can qualify for 75% gain exclusion. And if you hold it for more than 5 years or 5 years or more, then you get the 100% federal capital gains tax exclusion within those limits. So the new provisions within the law certainly provide a lot of benefit. One last point is that another thing to consider here is, does the C corporation have subsidiaries? If it has wholly owned subsidiaries, whether they are subsidiaries abroad in another country, and we often see that with companies here that may outsource their expenses and cost centers to other countries, there's what we call a look-through test. And the IRS is going to look through and say, we will consider the global assets and in terms of activity and make a determination whether those assets, what we often refer to in the business as bad assets, include those in this 80% engaged in business activity. And if they will be pulled in to make a determination if you fall under that 80% threshold or you continue to be above the 80% threshold. There are a lot more questions I'm sure that you will have, and we'll be having lots of breakout videos as a result of this. But high level is that it is entirely possible to exclude a portion of sale proceeds from federal capital gains tax. And that's important, federal, not state capital gains tax, but federal capital gains tax in the event of sale, if you're in the right business, if you've been structured properly, if the stock has been issued appropriately, and this has, of course, been fully documented in the process. Hope you found this useful. And if you have any questions, please feel free to reach out and engage with corporate counsel that really understands this. Have a wonderful day.